General's Poughkeepsie and Plattsburgh regional offices, and they will be covering various topics. For example, eviction rights, rent increases, limits on fees, and many and more. If you have any questions, please type your questions in the chat and we will try our best to answer them. Do not interrupt, be respectful, as we have quite a bit to cover. I'm going to be monitoring the chat, so we'll make sure that we will try our best to get to those questions. And we are going to be recording this call as well. So I am going to start the recording if I could
I
find it.
started it already, Yvonne.
You already started it? Okay, so
Yeah.
that's why it's recording. Okay, great. All right, so this call again is going to be recorded. This is all internal. This is our allies. We will be posting it, most likely posting it on YouTube, on websites of the Attorney General, and even MH Action's website. Once again, please hold your questions for the end. And with that being said, I am going to keep my eye on the waiting room, and I'm going to pass it over to Tara.
Hi, everyone. My name is Tara Glenn. I am a managing attorney for the Legal Aid Society of Northeastern New York. I'm out of our Plattsburgh office, so we cover 16 counties in upstate New York. I've been doing this for about 12 years, and mobile home parks are a specialty to me. I live in the North Country, and we have dozens, if not hundreds, of mobile home parks up here. I'll be doing this section with Lucy. So Lucy, I'll pass it over to you to introduce yourself as well.
Thank you. Hi, everyone. I'm Lucy Turner Iannuzzi. I'm an attorney with Legal Services La Hudson Valley. I help run our Goshen and Monticello locations. And I've also done a lot of work with manufactured home parks, advocating for habitable housing, as well as fighting evictions. So I'm really excited to get to pair up with Tara on this. And you'll also be hearing from me again when I talk a little bit more about warranty of habitability in a bit. All right, so I can jump right in. Tara and I are doing this together, so you'll probably hear from both of us. Here we go. All right, so we're just going to cover a general overview of evictions in general, and including some information about manufactured home parks. Starting out, summary eviction proceedings are the proceedings that have to be brought before the court in order to try to evict tenants from their homes. So the way that those cases are started is by service of the notice of petition and petition. These documents have to be served on the respondent, who would be the tenant. And there's three general ways that that service can be done. And we're raising these today because it's important for folks to understand that you don't necessarily have to be personally handed the paperwork. A lot of times we'll see folks come in and say, oh, well, I didn't get it from someone directly, or I just found it on my door, or I got it in the mail, and I didn't think that that was real. So we're bringing this up right off the bat because the case is started by service. It can be personal service, which is pretty straightforward, right? Someone hands you a copy of the paperwork. Or it could be what we call conspicuous place service, or otherwise known as nail and mail, where if they've made attempts to serve you personally and haven't been able to achieve that, then they could stick it to your door and then do follow-up mailings by certified and first-class mail. Or there's also the option that they could hand it to someone of suitable age and discretion, which is the alternative service, where essentially they're handing it to someone else who is present, who appears to be, capable of handing those papers to the person who is meant to be served, and there would be follow-up mailings as well. All right, so let me see if I'm able, there we go. So there's two types of proceedings. I'm going to start with non-payment proceedings because that's pretty self-explanatory, right? Non-payment is specifically for when a tenant has defaulted on payment of rent. You can only be evicted in a non-payment proceeding for non-payment of rent specifically. It can't be random fees. It can't be, water fees or any other kind of non-rent fees. So that's something that's very specific. As far as holdover proceedings, this is more of an umbrella term and it covers kind of everything else. So the most common versions of this are termination, say like expiration of someone's lease, or a landlord or manufactured home park owner has elected not to renew someone's lease. But it could also include like violations of leases. So this is kind of like the catch-all phrase for everything. And they function a little bit differently, so. All right. It's a little bit of a lag when I try to move the thing, so I apologize for being slow with it. All right, so adjournments. When you're going to court on these two different types of cases, this is the first step of, this is the first question that we often get asked by folks. What do I do when I get these court papers? We're going to go into a little bit more detail of what your options are, but the first thing I want to tell you is go to court. Do not ignore the notices that you are getting, because that's a common mistake, especially if you don't think it was served on you properly, or if you think that it's not legitimate, or your landlord or manufactured home park owner said, hey, don't worry about it. You don't have to go to court. No, go to court. If you get court papers, safe bet, go to court. When you're there, under the law, at your first appearance, if there's triable issues of fact and the issue's been joined, then either party can ask for an adjournment of at least 14 days. So what that means is basically the party showed up and someone doesn't agree with the paperwork, and ask for an adjournment. So this is where we often inform folks that you should make sure you go to court, say you don't agree with the paperwork. If you don't, make sure you're telling the truth, and ask for an adjournment to look into your legal options. This is a good way to enter basically a general denial and also get your opportunity to take advantage of this adjournment that the court will give you. There can be additional adjournments, but it is discretionary, so it's up to the court whether or not they grant those. And you'll see on a lot of these slides, there's additional information, but we're going to cover the highlights of it. And if there's any questions too, don't be afraid to reach out to us. All right, so answering the petition. This is where I was saying, make sure you show up to court and say if you agree with the paperwork or not. The rules for actually answering are defined in the law under RPA PL 743. But the important highlights to notice are, or to know, are that you can either do it in writing or you can verbally state on the record to the court, make sure it's being recorded, your answer. And as far as what this is, it could be an opportunity to raise defenses. Basically, you're saying reasons why this court, why this case either should not proceed as it's been pled, reasons why the landlord shouldn't get the relief that they're seeking. Also could be an opportunity to raise counterclaims. We're going to talk about some of these elements more in depth, but this is just kind of a general overview of it before we jump into that. But again, I'm going to keep saying this. I'm going to annoy all of you. Show up to court if you get court appearance, if you get a court notice, and at very least say that you don't agree with the paperwork. As long as you don't. If you do, then that's a different story. But you have options to say, dispute what's happening. Okay, so now we're going to talk about those affirmative defenses, and there's quite a few. So Tara, Tara, you're going to split this up. I'm going to do that 100 times. I'm so sorry.
I'm used to it. Not a problem.
It's probably the worst. I still sorry though. All right, so we're going to split these up, and there's a few different ways that each of these can be used. But the overview of it is there's classifications of what defenses are available. So there's procedural defenses, which kind of have to do with the steps that are taken in order to bring the case. There's non-payment defenses, which are specific to non-payment cases. Holdover defenses, which are, you guessed it, specific to holdover cases. And then there's warranty of habitability, which I'm going to talk to all of you about at length after this, and then also retaliation, because the last two were ones that we often see in court. Okay, so I believe I was going to do probably the first two of these, right? Okay, so affirmative defenses, procedural. So this is where we're saying that things that should have been done prior to the case like weren't done properly. One of the most common versions of that is that service wasn't done properly. Remember at the very beginning, we talked about the 3 different ways that you could be served with your court papers. And you can, if the law wasn't followed closely as far as those 3 options, then there is a defense to raise that service wasn't done properly. And this would put the burden on the petitioner to have to prove that it was. So what would result if someone raises this defense saying that they weren't served properly is, as you can see on here, a traverse hearing. It's almost like a mini hearing prior to a trial where the petitioner would have to prove that service was done, and folks are able to give testimony, exhibits can be admitted. And if ultimately the court decides that service wasn't done properly, then the case could be dismissed outright. Or if the court decides that service was done properly, then it can proceed to the next step, which would likely be trial. A few notes about service. It has to be done properly pursuant to our PAPL 735. So that was those 3 options that we talked about. Sometimes there's issues with those alternative versions of service where, say, they nailed it to the door. They don't actually nail it. It should just be taped or something, but not trying to say it. That's just the term of art. Where the mailing isn't done properly, the follow-up mailing for either the mail-in mail or the person of suitable age and discretion, where, say, they only did it by certified mail or only by first-class mail, or the timing of when they mailed it. Those can all be reasons why that service wasn't done properly. If it's by personal service, sometimes they serve the wrong person or the description doesn't match or things like that. So there's still ways to be able to dispute service if you genuinely believe that it wasn't done properly. And then as just a quick note, as far as the timing of service of the notice of petition and petition, it has to be served to the tenant or respondent no fewer than 10, but no more than 17 days before the first court appearance. If someone is served outside of that very specific window of time, then under 733, it could be a defense or potentially grounds to get a case dismissed.
If I can hop in really quick, Lucy.
Please do.
So one, I do want to, as you can see on the slides, we have the weird letters with the numbers. Those are legal references. The CPLR references one law, our PAPL references another set of law. And we just like to include them in the slides in case people are interested. If you take notes, you can Google these. These are available for free through like the New York State Legislature web pages and things like that. So just a helpful reference, and that's why we've included them. And then to piggyback off of what Lucy's saying about how important service is, not only should you absolutely go when you get, if you ever get court papers, but to remembering how you came across them, whether they were served, who served them, when they were served, how many copies in the mail. One of my favorite ones is when a client of mine got their papers shoved under their windshield wipers on their car. All of those weird details are very relevant when you go to court.
Right. No, that's such a good point. And also if you have, say, like mailboxes that are separate from your homes, so sometimes there's like a grouping of mailboxes. If it's just stuck to your mailbox or put in your mailbox, that's not the same as putting it on your actual home. So that wouldn't constitute proper service. And then one last note on this too is that this should be raised at the first appearance. So if you think that there's problems with service, even if you're appearing without an attorney, that's something to bring up to the court to preserve that defense, because once you've appeared, it could be deemed as waived, and it's not something that you want to waive if it's something that you don't think was correct. All right, so then the other one I'm going to talk about is the improper court, or otherwise known as subject matter jurisdiction. And this is really important because it's not waivable. This could actually be raised for the first time on appeal. Like, that's how serious this is taken. And basically what this is saying, that these cases have to be brought in front of a court that actually has the authority to hear the case. Now, statutorily, a lot of the justice, most courts actually have the authority to hear these, but if it's not brought in the right location, so say you have a case that's in, just trying to think of like places like in one town, say it's in the town of somewhere, but they bring it in the court of somewhere else, it's not the right place, right? So that's a reason why the court may not have authority to hear the case for where the premises are located. Additionally, it can only be brought between parties that actually have standing. So if someone who's bringing the case doesn't actually have authority to be trying to evict the tenant, that's another reason why another defense that could be raised, and also something that could potentially result in the case being dismissed. Another option, another common example is, say the tenant's already vacated before the case was started. Eviction matters are specifically meant for as an option for landlords or manufactured home parks who are seeking. Yes, Yvonne. Oh, you're muted.
I just saw on the chat, they want to know what PAP 735 is. I know you
sorry,
went by that already.
Sorry, so real property proceedings and action, right? Or real property actions and proceedings law. So it's the part of New York state law that describes kind of the process for an eviction versus real property law, which is the RPL, which kind of gives the definition of what things are. So it's just a section of the law, and like Tara was saying, these are all available readily online. And if you're going into court and you don't have an attorney helping you, you are not expected to be able to cite these laws and rip off like the perfect explanations of them. It can be enough to just say, hey, I don't think this was served right, or I didn't actually receive these papers. So I don't want anyone to be feel like you're being quizzed on this or that you have to memorize it, because it's enough to just explain it logically.
Yep, and I agree. I like to include them in presentations because there's some people who like to afterwards go look things up.
Yep.
And as Lucy said, the other people, we all learn differently. So it's all just different ways. So I think I am. So I think it's my turn now. So some of the other common affirmative defenses that are raised, and again, these are a very small subset. We're just going over some of the really big ones that we often raise. Is one of the ones is warranty of habitability. I'm going to breeze through this really quickly just because Lucy is going to go over this in far more detail later. But this is something that you can bring up in a summary proceeding in defense of yourself to say, I shouldn't have to pay rent. I shouldn't have to pay all of my rent because the landlord didn't do what they were supposed to do, keeping the park habitable or keeping my home habitable if you rent your home as well. The other big one is retaliation. Retaliation, we actually have 2 slides over, so I'm going to go over this. I'm not going to read from the slides, but I'll go over them slowly each page. Retaliation is basically you did something that you had the legal right to do, and your landlord is now punishing you by trying to evict you. That's what the claim of retaliation is. So whether you are standing up for yourself, whether you are filing a complaint with a governmental agency, or you called a lawyer, for example, those types of things, and now your landlord is suddenly trying to evict you, that's retaliation. And there's multiple protections under the law. The big one that covers all tenants in New York State is 223B. Mobile home park tenants specifically have their own right as well in 233. Real property law 233, I apologize. There are some limitations on this. If it's not retaliatory, if the tenant is the one who caused the problem. It doesn't apply to certain types of housing, but that doesn't, sorry, Yvonne, that doesn't apply to mobile home parks. Retaliatory actions, however, and this is relevant in mobile home parks, can also include unreasonable rent increases, or unjust alterations to the lease or to park rules, things like that. If the landlord is found to have been acting in retaliation, as Lucy had said at a summary proceeding, you also have the right to file counterclaims, and retaliation can also be a counterclaim for potential damages. So the proceeding, what happens when you actually go to court? I kind of say jokingly to all of my tenants that when you think of a summary proceeding, you should think more Judge Judy than you should think Law and Order. Most of the time, especially in upstate New York, most of our evictions take place in town and county, or town and justice courts, or maybe city courts, which are much more informal than the big courts like Supreme Court, County Court, or even some of our New York City counterpart courts. The judge, if you go pro se, which is just a fancy way of saying you're representing yourself, the judge will listen to both sides. Typically, the petitioner, i.e. the landlord, the person who's bringing the lawsuit, gets to go first. Then the respondent, i.e. the tenant, gets to go. They hear from both sides. Both sides can provide evidence to support their side. One thing I always like to make sure people understand is your lived experience and your testimony is evidence. Tenants will often say, well, I can't prove that because it was just what the landlord told me, or it's just what happened, or I saw it with my own eyes. That's evidence. That's testimony that you can give the court what happens. But you can also provide other things that help bolster your story, right? If you have pictures, if you have texts, if you have other things. You are allowed to bring someone with you. Going to court can be scary. However, if you are bringing someone who is not a lawyer, right, your friend, maybe a mental health counselor or regular counselor or a housing advocate who's not a lawyer, they are allowed to be there to support you only. That's the key difference. They cannot speak to the court on your behalf. That has to be a position filled by a lawyer, but you can bring people. If you bring someone, they can, and they want to sit with you in court to be that support person, just know they cannot also be a witness. Witnesses have to sit outside the courtroom until it's their turn to talk. Once the judge has made their decision, the judge renders their decision, says, here's what I think. Sometimes they do it right then. Sometimes they want to wait. The proceeding can all happen on that first day. The proceeding could get adjourned based on your own request or the landlord's request, or it could be on the judge. The judge could, in listening to things, say, I want to think about this, or you all keep referencing this maintenance guy, get the maintenance guy in here and bring him back a week from now. And so there's all sorts of reasons that could extend the court time. And again, the judge might make the decision in the moment, or the judge might decide, I've got to think about this and I'll let you all know what I think. Usually if they take time, they'll do it in writing. A lot of times, if they're making the decision in the moment, again, at least in town and justice courts, you'll get what's known as an oral decision. They'll just make a decision from the bench. If you want it in writing, you might have to request it. You might have to say, Your Honor, could I please get this in writing? If the judge rules against you, I always like to tell people the worst case scenario so they can plan. Because if you win, you win. If the judge dismisses it, yay, you're done, you get to go home. If you lose, if the judge rules against you, then the judge could issue what's known as a judgment, potentially if there's money owed, and typically a warrant of eviction. As Lucy said, summary proceedings are about possession, right? So like if you moved out before the landlord sued you, that could be a defense. So virtually every landlord is always going to be seeking what's known as a warrant of eviction. There may or may not be money. This is just a sample of what a money judgment would look like. Obviously, the court would fill it in, but they're not very complicated documents. We have a lot of fill in the blank forms in New York State. A warrant of eviction, this is the scary one that people get freaked out about when it comes to being evicted, right? This is the document that says you have to leave. Warrants of eviction are for 14, 30, or 90 days, depending on what type of tenancy you have. So if you rent both your home and the lot from the manufactured home park owner, you could be evicted in as little as 14 days. If you own your home and rent the lot and you are evicted for non-payment of rent, you could be evicted in as little as 30 days. And if you own your home and you rent your lot and you're evicted for any reason other than non-payment of rent, you would have as little as 90 days. These documents have to be served on you by law enforcement. That can look differently in different parts of the state. Some places exclusively the sheriff's department. Some places have their own local police. Some people, I know in like New York City, they have specific marshals that do it. So it could be something like that, but the key part is it cannot be the landlord. The landlord can't give it to you. Landlord can't give it to their maintenance guy to give to you. Thank you for the copy, but that doesn't legally enforce anything. So again, to go with the scary time frame of the 14 days, that 14 days starts when the cops hand it to you. This is a sample warrant. You can get stays for various reasons. If you think the court made a mistake, you can seek to have the warrant vacated. This is the special law that allows you to do that. If you have a special reason that you think you need more time, this can include things like you are having an unreasonably hard time finding alternative housing, finding an alternative place to move your mobile home park to. This is where things like medical reasons, childcare, child being in school, those things can come into play. Note that these stays, especially under this law called a 753 stay, is largely discretionary. If you're interested in any of these, I strongly encourage you to speak to a lawyer because they can be complicated to bring on your own. So quickly, because I'm running out of time, what happens when you get it wrong? Oh, go ahead, Yvonne.
I believe this question you can answer pretty quickly. Can we pull our mobile home out if we get evicted?
Yes. If you own your mobile home, yes, absolutely. And in fact, that's why you have the 30 or 90 days if you own your mobile home, specifically to allow for you to move it. That's the purpose of the longer time frames. If you don't live in a mobile home park, you typically, and you're a tenant like in an apartment building, you get 14 days. So that's the specific reason. Just to briefly go over what happens if you think the court gets it wrong. You can move to vacate, which is a fancy way of telling the judge to say, I think you did it wrong, and here's a chance for you to fix your own mistake. Please take this away. Is the nicest way to say it. This can happen for a variety of reasons. The typical reason is for some reason you missed your first court date and you had a really good reason, like you were in the hospital or something, and the judge ruled against you because you weren't there. You can ask the judge to vacate that order and give you a shot at having a trial and defending yourself. The next big thing, if the court gets it wrong, you can appeal it. Appeals are where you take it from the court you were in to the next higher court up, county court, appellate division, or court of appeals. Again, if you're looking at appealing it, I would strongly encourage you to contact a lawyer just because it can get very complicated very quickly. Even if you end up bringing it yourself, you probably want some guidance. But I believe that's all my slides, and I don't want to keep talking past my turn. So, Lucy, I think you're next.
Yeah, and I think we had there was a couple of questions in the chat, and one of which I'm actually going to talk about in the next piece, as far as if you can withhold rent. So I will dig into that a little bit deeper, but we can certainly circle back if you have additional questions. And there was also a question, where do you move your home with limited resources out there? And it's really expensive, and that's a great point.
I will just say, Patricia, if you could actually save that question for the end, because I think some of our other slides will touch base on that, and we can answer that better at the end.
Yeah, but these questions highlight that the stakes are higher than already high stakes in some typical landlord-tenant situations, because if you're a homeowner and you're evicted from the lot, you could potentially face losing a home that you've invested a ton of money into, time you've built, as the place you live. So, if moving it is not an option, it certainly plays a huge role in what your options might look like and the losses you could take. All right, so I'm going to talk specifically about warranty of habitability. The reason why we're focusing a whole section on this is because this is probably the most commonly raised defense. And I also think it's also one of the most commonly misunderstood ones. And we'll talk about the elements of it, and then also some options and best practices. So right off the bat, the warranty of habitability is that every tenant is entitled to a safe and livable home that's free of dangerous or hazardous conditions, right? You should be able to live somewhere that is safe for human habitation. This is something that a landlord cannot contract around, so they can't put in their lease that they're not responsible for maintaining a safe and livable condition for any tenant to live in. It's something that we often will see them try to raise as a defense, being like, oh, well, the lease says otherwise, but that's not enforceable, and it's something that is strictly prohibited by the law. All right, so the warranty of habitability is governed by state, county, and local building regulations. But generally, we're going to look at two things. The Real Property Law 235B, you're going to see that a lot throughout the slide. Again, you don't have to memorize that. The big thing you need to know is warranty of habitability and what it means. And we're going to talk about how that specifically applies to manufactured homes once I get it to the next screen. There we go. All right, so manufactured home parks. As Tara had said earlier, there's a specific part of the real property law that addresses manufactured home parks. So I'm going to talk about what that actually means. And then like what the special rules are. So when you see that we're referring to RPL 233, again, don't worry about memorizing it. Just know that there's a special area of law that applies to manufactured home parks. So what constitutes a manufactured home park is a parcel of land that's privately owned, and it's used for the accommodation of 3 or more manufactured homes for year-round living. So if there's someone who has, say, like one individual home parked on like a vacant lot or on like, say, a large piece of property, that's not going to fall under these special rules and the definitions of 233. That would more follow the rules of like other housing arrangements like apartments or houses. So there has to be like at least 3 or more of these homes in one area. And there's 2 kinds of occupants that live there, right? So there's folks who are manufactured home tenants, who are defined as folks who rent both the home and the lot where the home is located. And then there's manufactured home owners who own their home but rent the lot where it's located. So different rules apply in some pieces of eviction proceedings or in housing rules, but for warranty of habitability, I'm going to talk about kind of the difference of how those come into play and why it's unique. Okay, so as we described what the warranty of habitability is, I'm going to tell you about the elements of what it looks like when the landlord's not complying with the warranty of habitability. So I broke it down into 4 general pieces because this is how I always like to look at it when I'm evaluating a case and also helping someone prep for a trial or any kind of defenses. So first, there has to be an unsafe or unsanitary condition. So that's pretty straightforward, right? But it has to have not been caused by the tenant or someone who's invited in by the tenant, or so say you have a guest who comes over and they break something, or one of your children or one of your pets. That's not something that's necessarily going to be the landlord's responsibility to fix in all circumstances. So it has to be something that wasn't caused by you or someone you invited in. This is the big piece. A tenant must have provided notice to the manufactured home park owner that there's a need for repair, that these conditions exist and that they need to be repaired. And then that request for repairs is not actually accommodated to in a reasonable period of time. Now, what constitutes a reasonable period of time is not something that's like statutorily defined. It's not something that's strictly under the law. There is case law that kind of describes this, but if you think about certain things like, say, not having water or not having heat in the winter, a reasonable period of time for that is a lot shorter than there being, say, a piece of carpet that needs to be replaced or something along those lines. So the important thing is let them know about it and then keep track of whether or not they do anything about it. And if they do something about it, is it adequate? Does it actually fix the issue or is it an ongoing issue? All right. So this is the thing that oh yeah, sorry, I do talk too fast. I saw that in the chat. Sorry, everyone. All right. So
Lucy,
what are your
one thing, maybe just explain that when you're a manufactured home owner, what the warranty of habitability might apply to.
Oh yeah, definitely. That's gonna I promise that's in
okay
in here. But yes. So thank you for that. Let me go back then. Correct. If you're a homeowner, it applies a little differently for you versus if you're a tenant. Because you own the home, the landlord is not necessarily responsible for the conditions within your home, but they are responsible for portions of the property. Correct. Pamela just put it in the chat. She beat me to it. Correct. So they're only responsible for the parts that are outside, common areas, things that would say if they're in control of the septic system or, you know, some part of the infrastructure that you may benefit from as an owner, but isn't directly within your home, that's something that they would be responsible for. So that includes roads and other common areas like that. Also, if there's conditions such as like unsafe trees and things like that, that they need to make sure that they're maintaining so that nothing's falling on your home or causing damage, then those are their responsibilities, but they're not going to be responsible for, say, an issue like your stove's not working or there's an issue in your bathroom. If you're a tenant who rents the home as well as the lot, then it's going to apply pretty similarly to how it does in apartments or homes, where they would be responsible, as long as you didn't cause it, to make sure those conditions are maintained in a way that's habitable. Thank you for bringing that up, Justin. And
Lucy, one last question. What if you're a rent to own? Because that's sort of a hybrid situation, right?
Right. So I believe if you rent to own, it still applies as if you are a renter or so of the place until it's actually yours. So it absolutely still protects the conditions within the home until you're the actual owner.
And if I may, just to tag onto that, regardless of what your rent to own contract says.
Yes.
It doesn't matter if your rent to own contract says you're the homeowner as of signing. No.
Yes.
Until you get title or bill of sale.
Yes.
No. Anything in the home is landlord's. Sorry, go ahead.
I've been in court many times, probably not acting in my kindest way, saying you cannot contract away the warranty of habitability responsibility. So, but Yvonne, I saw your hand was up.
Yeah, I just want to add to this. Pamela said, I thought the park owner was only responsible for repairs outside or under your house. Can you elaborate on that?
Yeah, so that was the common areas or the parts of like the infrastructure that the homeowner is the manufactured home park owner is responsible for. Yes, that should be their responsibility. As far as under your home, if you mean like again, part of that infrastructure or like septic systems, things that they are responsible for maintaining, then yes, that's their job. They need to fix that. And I know that that's a common issue that we've already seen in the chat and that we've all seen quite often in
Yeah.
our work.
Can I piggy
I was
back on with you, Lucy? What I understand as an organizer, not an attorney, and I want to
Mhm.
be clear with everyone on the call, not as an attorney, but as an organizer. We are and I live in a manufactured home, so this is why I'm real diligent with this question also. So we're responsible for anything above ground under our homes. Anything below the ground, it is the park owner's responsibility.
That's a good way to put it.
Yeah, it comes up frequently when the issue of frozen pipes come up, and
Yes.
it's really the homeowner's responsibility if you own your home to insulate your own pipes underneath, because they are only responsible from below the pipe that's coming out of the ground.
I will always share, I will also share here that the best thing you could do for your pipes not to freeze is to get heating tape and protection around your water pipes. It is the best thing to do. I did it from day one. 10 years I'm living in the community where I live, and my pipes have never frozen. So it does work.
Pro tips right here. Yeah, so just kind of to sum that up, like if the manufactured home park owners agreed to provide hot or cold water, heat, light, or any other like service or facility that might be available, this is right within the law. Then and if they like willfully withhold that or don't furnish it or don't fix the issues, then they could face violations for that. All right, so what do you do if these issues exist? And I promise we will at the end have room for more questions and stuff. I just don't want to take up everyone else's time because I already did that to Tara. All right, so your options, I'll be quick about this, are to withhold rent. Just be careful when you're doing this, all right? A lot of folks, this is what I meant when I said it's misunderstood. Warranty of habitability is often misunderstood as basically a like it lifts the responsibility for you to pay your rent, and that's not the case. It's an option for you to withhold your rent, but ideally you should be putting that full amount aside and not using it for anything else. Now we know the world doesn't work that way, all right? And I'm not here to like say if you can't do that, that's any kind of judgment from me, but under the law, no matter what the conditions, you're still obligated to pay rent. That's still your responsibility. So if you withhold rent, you are supposed to put it aside. Or you could potentially withhold part of your rent, right? A portion of it, which is more realistic of what an option in court could look like. Ultimately, if you have a trial on this, if there's a deduction, you could withhold part of rent, but you should inform the manufactured home park owner why you are withholding and how much you're withholding. Oh, I see a hand up. Do you want me to answer that now, or do you want it at the end?
Let's hold all questions to the end because we're running a little bit over.
I'm sorry. All right, I'll do this really quick. I'll talk about repair and deduct. If you wanted to have someone, if you paid out of pocket to have someone come in and make the repairs, and you kept the receipts, then you could submit those with the reduced amount of rent to accommodate for that amount. But make sure you keep receipts, and just know that there's always a risk with withholding rent or repairing and deducting that they could still bring a non-payment case against you. And then in Article 7D is a newer option where you can bring an affirmative litigation trying to get a court to order repairs to be made. All right, sorry everyone, I took up way too much time. So I can always talk about best practices later if we want to move on to the next piece.
This is super important. You go for it. I can shorten up mine. Go for it.
Okay, so best practices, and make sure maybe take a screenshot of this. First things first is make sure you inform the manufactured home park owner in writing about the conditions. So that could be text, email, even an old school letter. If you do any of these things, keep copies of them, keep screenshots of them. If you send a letter, send it by certified mail or priority mail, and keep a copy of the letter that you sent. Another huge thing you should do is document these conditions. So take photos, take all the photos, take videos, and keep a written log of when things are happening, when you've contacted the manufactured home park owners, when you have requested repairs to be made, if any repair attempts have been made. And if they do come in and make repairs, document what those repairs look like and then the follow-up, because sometimes they're just Band-Aids, right? We know that, so that's something to keep track of. You could potentially contact your local building department. However, this can be a double-edged sword. One thing that could result is violations being issued or other things that might help motivate them to make the repairs. But this also, if the conditions are bad enough, could result in a condemnation, which would mean that you would essentially be losing your housing without any court process or protections. There are pieces of due process within that, but it works very differently than the eviction process. So just always weigh that in when you're thinking about it. If they agree to come in and make repairs, you should make every effort to comply with that, right? You want to make sure that if you've requested repairs and they come to try to do them, that you're not turning them away or refusing to let them in. If there's safety concerns, that's something that you might want to either have someone who you know there with you, or like put some safety options like in place so that you can still try to accommodate their attempts to make the repairs. But again, document everything. And last piece, if you're working with any kind of community partners or agencies who might be helping you with your rent, say you have a voucher or you're working with DSS who's paying part of your rent or anything like that, you should keep them informed of what's going on, because sometimes they do their own inspections and have their own processes to come in and also help motivate them to make repairs. All right, sorry, Tara. Take it
No,
away.
you're good. It's really important. And then also, just to actually loophole, cling on to what Lucy's saying, especially in terms of documentation and things like that, a great way to also document it is to have witnesses, such as your name. If you are, let's see if I can move the slides around. I don't think I have control over the things
I can
yet.
try. Do you want to move it forward? I can do that for
Yes,
you.
please. Thank you.
got it. At least I think I can. All right, maybe I not.
Well, I'll just keep talking and the slides will catch up. So what you could do is in a mobile home park, you could form a tenants and or homeowners association. So they're often called homeowners association in mobile home parks because one of the key things that make living in a mobile home park so special is that you are homeowners, right? And so that's why we call it that, but it gets kind of a bad rap because people think of mobile home associations as like tyrants caring about how long your lawn is. And that's not the homeowners association I'm talking about. Did we lose slides or did I just lose slides?
No, they're all gone.
Okay.
Sorry.
Someone else.
Sorry, that was me. I'll get them back up just
Nope,
momentarily.
you're good.
You could have
Not a
totally
problem.
given the blame to me, Justin. I would have taken it because I thought I did it.
All right,
So I'm just gonna-
Justin, so run the slides so we could continue.
Sorry.
In the meantime, I'm just going to keep talking about homeowners associations. So so I will say any tenant in New York State has the right to form a tenants association, and just like that in a mobile home park, and you can call it a homeowners association or a tenants association. But it's really about organizing the residents for collective action, right? Part of the reason this is so critically such a valuable thing that you can do in a mobile home park is a mobile home park is a critical source of housing in New York State, and mobile home park residents have so many protections under the law. If you're not already familiar with this law, this is one law I would recommend everyone on this call actually write down and go look up if you have a chance. It is Real Property Law, Section 233. It is for those in the business. We kind of call it the Mobile Home Park Tenants Bill of Rights. It's huge. If you print it out, it's like 27 pages, single-sided, and it has subparts A through X, I think. And that's just one of there's so many special protections that you can hold landlords accountable to, but for anyone who's lived in a mobile home park or is aware of the kind of climate of what's going on with mobile home parks, you know that too often owners are not being held accountable to these. So by collective action, you can, here we go. Here's just some of the, here's some of the legislative findings as to why mobile home parks are so critically important. these aren't super important to go over, just to note that New York State government agrees how special mobile home parks are and how much the residents in them need to be protected. There was a massive change to the law in 2019, and then it was further changed in 2023 when the legislature saw that the 2019 changes weren't going far enough. Can I switch it? Let's see. There we go. Here's the Bill of Rights. Again, I'm not going to go over these in too much detail, but this is just to kind of highlight just how many special protections a resident in a mobile home park has. These protections are not out there for all tenants in New York State.
Slow down.
Yep. There you go. So fundamentally, so I talked about why it's important. Why, how, what is a homeowner association, right? It's basically everyone coming together for the common goal of their community. It can be incorporated. You can make it a full-fledged nonprofit. You can go nuts and go for a 501c3 status if you wanted to, or it can be a very loose grassroots collective between the residents in the park. You get to choose how you want to run it, what rules you want to have, what your function is. But what it serves as, again, to go back to the warranty of habitability, that's a great example of if one resident's having a problem, they can go to the HOA and the HOA can see if multiple people are having this problem. Is this my water or is this everybody's water? Is this my septic or is this everybody's septic? Anyone else have a problem with that tree? What about what's going on with the roads, right? These are problems that affect your entire community. And instead of, lot 1, 3, 7, 12, and 15 individually complaining to the landlord, when you collectively come together and say, hey, we all think this is a problem, or we're all going to withhold our rent, is far more effective in generating change than individual homeowners. And that you don't feel as alone in making some of those statements to the landlord because you have the protection of your neighbors doing it with you.
Tara, do
Yes.
we need an attorney to form a HOA?
You do not need an attorney to form an HOA. Not even if you want to incorporate. If you want to be a corporation, you don't. I will say in New York State, you have to be a nonprofit corporation if you're a homeowner association, but you don't actually need a lawyer to do that. I would recommend talking to a lawyer, but you don't have to. And also critically, forming an HOA, joining an HOA, or participating in an HOA is protected under the law, and your landlord cannot take action against you for doing that. And that is protected not only under the retaliation I talked about earlier, but it's also protected under that Bill of Rights, RPL 233. So how do you do it? Talk to your neighbors, right? You don't have to have everyone in the park. It can be a small group of people, a small contingent. Ideally, the more people, the more effective your HOA can be. And you can also do things other than just battling with your landlord. Some things in a park, like beautification, right? Maybe you have people who really care about that. Maybe you want there to be a playground for the kids in the park, and you want to generate fundraisers so that you can do that. There's all sorts of ways that, again, as the community, you can come together and make your community what you and the community want it to be. You do need to have rules. Again, if you incorporate, New York State is going to require that you have some of those rules. Any group needs rules to function. Book clubs need rules to function. That's not, it's not a very high standard, but the main part of its democratic control is all within the control of the residents of the park. Yvonne, I didn't know if you wanted to talk about anything because you are an organizer about these things.
Thank you. So I will share really quick because we have still quite a bit to cover, but I will share with everyone on this call. I am the New York community organizer. I've been with MH Action for February 26th. I will be 6 years with the organization. Many of you on this call do know me. The biggest message I send you is to stand up, You have rights, you organize. Join the HOA, do an HOA in your community. Not only that, as you all know, and I'm pretty sure they're going to talk about it, is we won the right of first refusal, the opportunity to be able to purchase our community if and when the park goes up for sale. And we could always set up a separate call and I could give you more feedback as an organizer. But my biggest message to all of you is please organize in your community, stand up, do not be afraid. This is the biggest barrier that we see in all communities when we go into communities. People are scared, especially our seniors, our veterans, our low income families, single moms are always afraid. You know what? We protect us that have the strength, want to protect the seniors. So even if I will say I have a senior in my heart at the moment that is going through a problem that we are trying to support her, but she is so afraid of the park owner, of the community manager. You got bullies. Do not be afraid. Stand up and organize. You want to talk about it some more? Contact me. I'll be happy to connect you with other leaders that have been in the fight for many years, for quite a few years. Some of them are on this call. Some of them know how much of a fighter I am and how much we need to fight to protect what's ours. And we do not stand for anybody to take away what's ours. So I'll leave it right there. Thank you for listening. And continue to put your questions in the chat.
And so thank you, Yvonne, and your experience on that is beautiful, and I appreciate you sharing your sentiments. There is nothing under the new laws that have been passed that require people to organize in a mobile home park, but the critical thing is that it is protected. There's a lot of generalized fear when it comes to forming these organizations of tenants feeling that they're going to somehow be punished or adverse action will be taken against them. While that has certainly not been the case for many years, the key takeaways from the legislature from 2019 and then again increase in 2023 specifically is that this is protected behavior. You have a right to do this if you want to, and that this is about giving residents, specifically in mobile home parks, the power to do this themselves should they want to. What works in one park doesn't work necessarily in other parks. It's all about that freedom and democratic control within your communities. As Yvonne talked about park sales, there is a new law. It was passed in 2023. It went into effect in April 2024. The right of first refusal for mobile home parks in sales. Very briefly, these are some of the big three legal changes that happened in 2023. That it strengthens to go in reverse order. The bottom ones, 7422, strengthens protections in New York State to be in line with federal law, which makes it easier to enforce things, especially when corporations are buying up mobile home parks who are out of state and they may be more familiar with federal laws than they are with state laws. The middle one, 7403-A, I can't read, creates more funding opportunities for people in mobile home parks to purchase, manufacture, or modular housing or improve it or replace their existing homes. And then the big one that I'm going to spend much more time talking about, 5549-A, which is the right of first refusal. Again, you don't have to memorize these. This is just in case you're interested and want to look it up yourself. Again, just kind of going over why this is so critically important. From 2019 to 2023, sorry, I'll talk slower. I keep doing that. I get very excited about talking about these things. But they found that there was a big gap from their intended protections in 2019 to 2023 that people in mobile home parks needed to have this right to buy their home, to buy the land that their homes sit on, and that there needed to be more financial opportunity available specifically for people in mobile home parks to repair, replace, or buy new homes to go into parks. So the right of first refusal, this is going to be the densest thing that I'm going to go over because I kind of do have to just read this. So when a mobile home park is sold or is going to be sold, or the owner gets an offer from someone else, the mobile home park owner has to tell whoever is interested in buying the park that the residents have the right to buy the park first. If the mobile home park owner then accepts an offer or looks to accept an offer, the mobile home park owner has to send a notice to every resident in the park or the homeowners association, if one exists, that they intend to sell the park and the details of that deal so that the HOA or the residents, should they want to form an HOA, can work to match that offer. If the homeowners decide to act on that right of first refusal, if they say, yes, park owner, we want to buy it, we want the option to buy it, we want to look into buying it, they have to send a proper notice. They have to send a notice to the homeowner saying that, and then that pauses the sale to give the manufactured homeowners time to actually put in an offer to purchase the park. So,
Tara, I'm going to interrupt you for 1 second. I want to give people this comment that Dio gave. And Dio is a person in a manufacturer home that we could get into a longer conversation with that. And her comment is, it is critical to form an HOA and fight against a purchase. We tried and failed before the law changed in 2023, but a park in Lake Place just succeeded. Yeah. They just succeeded. So it's not impossible. You need to organize. That is my biggest message to all of you. Organize. Thank you. Sorry to interrupt.
You're fine. And I can say from professional experience, I have worked with a number of parks who have organized. So it is possible to do. So going back to this park sales, I just said a lot of things. So we're going to now go over it slowly because I know it was a lot. So homeowners association, right? When a park is up for sale, an HOA, right? A homeowner association of the residents in a mobile home park who own their homes can collectively come together. It has to represent more than 50% of the homeowners in the park. Now, to just be an HOA, you don't have to have that many, but specifically if you're interested in triggering your right of first refusal, your HOA, your collective has to represent more than 50% of the homeowners. You have to have written consent from your members that you want to form the HOA. You then have to notify the park ownership that you have an HOA and who your leadership is. Usually there's a chair, a vice chair, a secretary, those type of typical positions. You have to tell them who it is, and you have to give them a mailing address, right? So who does the owner then talk to if there's an HOA? For this specific purpose, for the purpose of the right of first refusal, the HOA does not have to be incorporated. There might be other reasons you want to be incorporated, but for this, you don't have to be. When the park goes up for sale, as I said, the park owner might put it up generally. There's actually whole websites like a Zillow for mobile home parks. So they can put it up for sale themselves. They might decide to offer it specifically. You see this a lot, at least in our neck of the woods, right? Where, mom and pop own it and they want to sell it to their nephew or something, right? They might offer directly to someone they know, or they receive a random offer for someone. This is especially my understanding of what's happening more in the Westchester Southern Tier area, where you have a lot of these corporations from out of state, sometimes just blindly making offers to mobile home park owners who are like, hey, I didn't know I wanted to sell, but that sounds like a good idea. No matter what, any of those scenarios, the park owner has to tell the person they might sell it to that the residents have a right of first refusal, and they have to tell all the residents you have the right of first refusal. So the notice is, what does the park owner have to tell the homeowners, right? They have to say that they intend to accept an offer and what that deal includes, right? So the notice has to include the price, the material terms, and that the homeowners in the park have the right of first refusal. How much time? From the time you get that notice that your park is up for sale, right? So when they say, hey, residents of the park, we're selling the park, you have 60 days, 60, to trigger your right of first refusal. You can do it faster, you can do it right up to the deadline. I laugh because I'm working with a park that did that and we did it on like day 59. I don't necessarily recommend doing that. It was very stressful. That's not the end of it. That's just the first step. Then you have 140 days total, right? From the notice, 140 days to actually make the offer. And it's a very confusing way to look at it because if you have to do that first step in 60 days, but if you do it in 20 days, you do it in 40 days, you do it whatever, you still then have 140 grand total to make the actual offer to purchase the park. Why I was saying before, one of the reasons it's so critical to have an HOA in a mobile home park is because if you do not already have one established, then that first 60 days becomes a lot shorter because you have to also form the HOA within that 60 days. So, right, if you already have an HOA, then you just have to decide if you want to trigger the right of first refusal. If you don't have one, then you have to organize, get the written consent, make members, make directors, make whatever, notify. There's just a lot more steps. And it's a very short period of time to do all that. Ooh. Ooh, I'm not working. Sorry, having technical issues. Bear with me for a second. So you assert your right. There we go. It worked. So you assert your right. Now what? Now what do you do? Right now, once you have the HOA, you asserted your right. You say, "Hey, we're going to purchase the park." What do? You work to purchase park, right? There are three main. There's two main things that you can do. You can either purchase it yourself and run it collectively yourselves as the residents of the park. Typically, we see that model being a cooperatively run park, or you could select a owner of your choosing to assign your rights to. Broadly speaking, within contract law, if I have contract rights, I can say these are my rights and I'm going to give them to Lucy, and now Lucy has all of my contract rights. So, right, you could do that. They say, we don't want this to go to this corporation in Texas or whatever. We want it to go to the guy who runs the mobile home park down the street because we really like that park and we think he knows what he's doing. You could do that too. There's funding available through New York State to, as well as other private and nonprofit avenues. A lot of residents I talk to get very nervous when it comes about this stuff because they're like, I don't have the money to buy a park. These parks are going for millions of dollars. There's funding available. I've never known a mobile home park that was bought by the residents that required the residents to put down money or any substantial amount of money. You might have to, depending on how you form your homeowners association, you might have to buy shares, but that's like $20, $50. It's not, you're not spending hundreds of thousands of dollars buying your park. Assignment, that's what I was talking about. Sorry. So again, going back to organize or not to organize, that is the question. Because once again, you do not have to organize. There's nothing in the law that requires residents in a mobile home park to organize. It does require you to organize if your park goes up for sale and you want to trigger your right of first refusal. That's the only kicker there. All right. I think I am out of time. And I didn't see if there was any questions or anything for me. I know this was a lot of information. I hope it all made sense. Thank you.
Okay. Awesome job, Tara. Thank you so much for that. I believe I am next on the agenda, y'all. Thank you everybody for bearing with us. My name is Sam Berkson. I am a housing attorney with Legal Services of the Hudson Valley. I've been with Legal Services of the Hudson Valley for about 5 years, and I've been in civil practice in the law for about 10 years. And so, okay, now I have control over the slides. Thank you, Justin. And so I'm going to be presenting for the next like 6-7 minutes, maybe 5-6 minutes about rent increases for manufactured home parks. And jumping right into it, Tara and Lucy had mentioned that we are operating out of the real property law, section 233, that manufactured home park bill of rights. And specifically regarding rent increases, those are covered by section 233B in the real property law in New York State. And just like a point of information, these laws have only really been enacted for the past like 5-6 years. And so in terms of like litigation and cases in court, we don't have decades of court records in terms of the authority of these statutes and how a lot of these issues would play out. But it's important, like Tara laid out, to recognize that the state in New York recognizes that manufactured home parks really should get some significant protections, and that applies to rent increases. And so the law in real property law 233B applies to all manufactured home parks, except for certain few that have affordable housing government contracts, and you would most likely know if you live in one of those manufactured home parks. So just very, very basically, can the landlord in a manufactured home park raise your rent? Yes, of course they can. By how much? That's really the question. 3% annually, anything up to 3% annually one time, that's okay. More than that, it depends, and I'm going to go into that right now. Now, on the bottom, you'll see this is real property law section 233 -B subsection 2, where this is all explained. And I'm going to explain it, and then I'll explain it again, and then I'll explain it again, just to make sure we get it. Rent increases may not exceed 3% above the current rent unless the manufactured home park owner has an increase in certain expenses. Now, rent is defined as all rents, fees, charges, assessments, and utilities. And a manufactured homeowner would have the right to challenge an increase that exceeds 3%. And what happens is the manufactured home park owner will increase the rent by above 3%. And if they do that, then the manufactured park homeowners, they'll have 90 days from the date of that increase, that proposed increase, to file for a judgment in the court to declare that rent increase unjustifiable. And so let me stay here with this 3% increase. Basically, if the tenant, if the manufactured park homeowners do within that 90-day window file a challenge to the rent increase, the manufactured park homeowner will be able to justify that increase if it's between 3% and 5.9%, 5.99%, as long as they can make a showing that they experience increases from operating expenses, property taxes on the park, or costs from capital improvements. And so it's important to recognize that you have a right to challenge it. They have a right to justify the increase if it's within that window. Now, I'm going to quickly go over the situation when a manufactured park owner would be allowed to raise the rents over 6%. And I'm going to very quickly breeze through this because it's very uncommon that um, manufactured park owners will actually do this. Rent increases for a manufactured park homeowner may not exceed 6% above the current rent, except if there's an approval of the park owner filing a temporary hardship application by the court. And so the court would consider the amount of the increase, the ability of the homeowners to pay the increase, whether the increase would have an adverse impact on the park, the time of the notice and the increase on the homeowners, and the duration of the increase. Um, I'll reiterate, I think we've spoken about this. Yvonne, you want to chime in?
Yeah, I wanna flag this for you while you're going through your slides. I have someone that says New York State Department of Homes and Community Renewal does not respond to complaints regarding rent increases. I have not been able to locate a court to file against a rent increase. There are problems trying to file against a rent increase.
Interesting. I mean, my response to that would be that the court system is very, very, very complicated. And so what you'd want to file with the local jurisdiction that would have governance over that matter, which would likely be the local justice court, town court, city court. And I you could get an order to show you would want to go to the court of local jurisdiction because they would have the authority to make the determination whether or not that was a proper increase. Am I wrong in that to my colleagues? Am I right?
Yeah, it has to be the Supreme Court for the county in which the
Supreme Court,
park-
right? Okay, so I thank you for correcting me, Justin, uh, and so yeah, right. You would go to the court of jurisdiction, but that wouldn't be the local court. It wouldn't be the justice court. It would be the Supreme Court. Um, and so that would have to be responded to by the court if it was filed. And if you were in a situation where you wanted to consider doing that and taking that step, I would suggest myself as a legal professional that you would find a legal professional. You would come to Legal Services of the Hudson Valley or another legal services provider to try and help you make that filing with the court. Thank you, Ivan, for that too as well. And so going to my next slide, still regarding the 6% increases, just very quickly, if a court did approve a manufactured park owner's temporary hardship application, then the court's order must very explicitly state the amount of the increase, the start and end date, the amount of the rent, the amount the rent will return to after the temporary hardship, and the court's findings. Again, this isn't something that's been that common, so I'm gonna continue because really the most common issue that arises is when the rent is raised between 3 and 5.99%. So if the manufactured park owner, and I guess there's a little bit of lag, I'm waiting for my slide to come through. If the manufactured park owner raises the rent by anything up to 3%, I mean that's just going to be something that they're allowed to do. It's going to be something that you might see on your ledger, and you might have a question about it, but it's probably not going to be challengeable. If they do raise the rent between 3 and 5.9%, then you'd be able to challenge it. And so just some things to be cautious about. If you are a manufactured park homeowner and you want to challenge any rent increase, the tenants, the manufactured park homeowners should pay the increased rent. and the park owner must hold the increase in escrow until the matter does get resolved. No one can be evicted for non-payment of rent increase before the court proceeding is over. And if the court holds the increase is unjustifiable and impermissible, the park owner must then refund the increase. So basically, just keep paying the increased rent if you're going to challenge an increase between 3 and 5.9%. You should keep paying it. And if the court determines that it was unjustifiable, you'll get your money back. Pushing one more out, I think. Yeah, this is just another chart. I know I'm kind of running on time, Marcy. I want to hand it off to you in a second, but this chart, it will be part of the slides that people can, view if they're circulated, and it basically explains the window for raising the rent 3 to 6% above that. Pivoting to one kind of completely different issue, related but different, before I hand it off to the next speaker. Another aspect of the manufactured home park bill of rights is subsection W, RPL 233 subsection W, which addresses tax implications for tenants. In a home park, in a manufactured home park where there's a local property tax exemption program, a lot of this becomes involved with the STAR reductions programs. A tenant is entitled to the rent reduction if the park owner receives a tax exemption. So it's a pass-on rule, right? If the manufactured park owner receives a tax exemption, then it must be passed on. There's a technical element where the manufactured park owner can maintain 2% of that tax exemption for their own overhead costs, but the rest of it must be applied and passed on. And so if you have any more complicated questions, or you have any concerns about that, reach us. You can ask questions or reach out to us outside of the presentation. So that's it for me.
Let me just jump in for a second with just one little note. Landlords are supposed to not charge tenants separately for their taxes. It's supposed to be incorporated into their lot rent. There are some circumstances where people will be assessed separately than the park, and that's if they're individually trying to get a senior or a veteran's tax exemption. But I know that people probably have the question about whether they should be paying or charged separately for their taxes. And the answer is no. There's actually a case out of the third department that speaks to this, that says that it stands for the proposition that you, as manufactured home tenants, should not be charged separately for your taxes. It should be part of the lot rent.
Great. Thanks, Justin. Thank you, everybody, for giving me a chance to present.
Hey, everybody. My name is Marcy Kobach. I'm from Legal Services of the Hudson Valley. I think I should get control over the slides in a moment, but I'm going to take the next part. I'm going to set a speed record without speaking too fast for our wonderful interpreters. I am going to talk very briefly about fees, and we're making this separate because fees are separate. Fees are not rent. That's a big bullet point that I'm going to give all of you. And this relates to something that we all of the attorneys on this call have said a jillion times, to be specific when you make payments to your landlord or the park owner. We do call it earmarking, so that you specify $ number, rent, September 2025, $ number, whatever else you may be paying in that same payment on that same check, a fee or something in that regard. Okay, as I just said, fees are not rent. In 2019, and Lucy alluded to this before, the New York State Legislature made that extra clear because it had been a big problem with people being evicted, essentially, for non-rent charges. It was a mess. It was terrible. And the legislature cleared it up. Okay. So now fees for manufactured home parks under our friend, Real Property Law 233, can only be for certain things. They can only be for utilities, charges, or facilities. Now, these have to be disclosed in advance, and a change in 2019, hear a lot about that year in 2019, that disclosure has to be before entering a rental agreement, before entering a lease, before entering a contract, right, which could bind a person to a certain amount of money. Prior to that change, it was just before occupancy, right? So you still had a contract. Now, any increases must be with at least 90 days written notice. And since 2019, it's clear there are other sections of our friend 233 which say what's a proper lease, right? And no fee increases are permissible without that proper lease. Okay, let's talk about attorney's fees and late fees. So this is really big. A lot of leases will say, okay, if I have to take you to court, I get attorney's fees. That's incredibly common. Now, since 2019, whether or not they put it in the lease, right? It's just the law, whether they write the words on the form or not. If the lease says that the owner can get attorney's fees, the park owner, then if the tenant has to sue the landlord and they win, they get attorney's fees. Attorney's fees are not something that just the landlord puts on the ledger because they feel like it. The owner actually has to win in court and have a court say that and say, okay, you brought the case, you all fought hard and well, the park owner wins, they're awarded this amount in attorney's fees. Let's talk about late fees. Late fees are also capped. They cannot be charged until the rent is more than, let me move this down, 10 days late, which is longer, right, than a tenant who rents an apartment as opposed to a lot. So it's 10 days, and they can't be compounded, and they're not additional rent. Fees are not rent. Prior to 2019, fees were capped. In 2019, the cap was reduced to 3%. Yvonne's hand is up. So
I wanna
Fire
ask
away.
you if you could elaborate a little bit there, because what I've encountered on ground with many families is the park, they'll pay late, though, and I know that late fees cannot be compounded on. These park owners are not respecting that law, because what they're doing is, let's say I pay my rent late, I go the next month, I pay my previous month that was late, my present month, don't pay the late fee because I don't have it. They'll turn around and take it out of my rent and apply it to the late fee.
that's why you got to earmark. And so, you know, these new changes in the law, maybe there aren't court cases specifically about those new changes, but there are concepts that come in. And one of those concepts that's old and has controlling case law governing it or about it is that if a person directs a payment, the landlord has to apply that payment as directed. So that's why you want to say, this check that I'm sending you, 97% of the total amount is rent for the month in which it is, for which it is being paid, and the other amount is for late fees. So the slide is not letting me advance. But that was about, yeah.
Marcy, just to be really clear, because sometimes we speak in legal language, what you're talking about is if you're paying your rent by check or money order, that there's a memo section there.
Yes.
And that's where you would put that this payment, and people might want to make two payments, right? Like in the same month, you might want to make your one payment just for rent and have on it say rent only for the month of September. And that way, if you ever went to court and they tried to take some of that money that was designated as rent and they try and apply it towards fees, you would have a defense in court that that in fact you have paid your rent, that they can't maintain a non-payment action because your rent is paid. And it would really prevent them from misapplying the money towards the fees, right?
Yes, that is absolutely correct. So, you know, if you pay, for example, by personal check, writing 2 checks is not a big deal. If you're paying by money order, where there's a fee for each money order, you might want to decide to write very small and carefully everything on the one memo line, so that you can designate the payment for what it is for without an extra cost. And then portals, different sorts of payment portals are becoming more and more common. I understand many of them, you have the option to include a memo. If you don't have that option, you still want to communicate simultaneously your specification of what you are paying. You know, so a letter, email, text, the payment I just made on the portal is for X, Y, Z. If the lease, I'm not seeing everything on the chat, but I see this. If the lease states that all fees are additional rent, that is bogus. That is not a valid lease clause. Like Lucy was talking about, you can't contract around things. The legislature was very clear. This is the law. We're the legislature. We say what the law is. Landlord, you can't say a different law in your lease. So even if it is in the lease that it's additional rent, that is what we call not enforceable. It does not hold water. And
Marcy,
I think I should turn it over, actually.
no, wait,
You,
Marcy, I have one
Justin,
last,
right now.
I have one last question. Say it, the 3%, it's not 3% of your outstanding balance.
It's that month's rent. Yes, one of the slides specifies. So people, I think, are gonna, you know, have these available so they'll be able to look at the text. And like Tara said, our, you know, laws are publicly available for free so that people can look at the text of the slide and the text of the law. But that's right, the law specifies that it is 3% of that month's rent if that is more than 10 days late.
And just to be clear, so if for some reason you paid like 90% of your rent, they could only really charge you 3% on the unpaid portion of that month's rent. It's the 3% of the outstanding payment, not the full, you know. I only bring this up because I've seen a variety of different practices at different parks, and not all of them are going to comply with this law.
Yeah, but so big takeaway is specify what you're paying and keep records of everything. And you know what, really? Keep records of everything for 6 years. And I think that's it for me.
Well, I want to hop in real quick before Justin, you go. The tax, there's a big concern, and I've been watching the chat, and there are people being charged for property tax, school tax on top of the lot rent, and they're not getting breaks on their rents or anything. Is that legal? And yeah, they want to know a little bit more about tax. Are park owners aware of these fees and regulations and taxes? Who enforces these owners to obey by these regulations? There's a specific park, and there's a lot of residents from that park on this call, and they are very upset, especially I mean, everybody is, but the seniors are even more concerned because they got to pay lot rent. On top of lot rent, they are to pay taxes as well. So what kind of suggestion or feedback can you elaborate? Anyone can elaborate on that to give them some kind of a little bit of answers on that.
Well, one thing that we're going to talk about next is about how to make complaints to the Attorney General. So my colleague Allison's going to take us through that process. That might be one way to address some of these issues that are
Wonderful.
affecting a whole park.
Thank you, Justin. My name is Ali Mussin. I'm an Assistant Attorney General in the Plattsburgh Regional Office. Justin is also an assistant, an AAG down in the Poughkeepsie Regional Office. I'm going to briefly cover the Office of the Attorney General, or OAG's consumer complaint process, and just a little bit about the OAG to begin with. Is it just lagging?
I think it's lagging. Yeah.
Oh, there we go. Okay. Letitia James is New York State's Attorney General. She is the People's Attorney, as we call her. Let's see here. All right. Oops, too far. There are 9, really too far.
Here, I'll get
Sorry.
it back. I'll get it back. Hold on.
Okay. Thanks,
There you
Justin. There are 9 divisions of the Department of Law. The Plattsburgh and Poughkeepsie regional offices are part of the Division of Regional Affairs, and we collaborate with other divisions listed here on a regular basis. If you believe that your rights as a manufactured home park resident were violated, or the park owner or management is engaged in illegal or fraudulent business practices with respect to the operating of a manufactured home park, we strongly encourage you to file a consumer complaint with our office. We require all consumer complaints to be made in writing, and the best way for the public to submit a complaint is through our online portal at the website located here. Next, we will show a video that walks you through the online complaint form on the OAG's public website. So what you've, oops.
Okay.
All right, so you go to I want to, there's a scroll down, drop down menu, file a complaint. There are categories, you select the most appropriate one. For housing and real estate issues, that's what you would select. There's a manufactured home park tab, and then your selection will bring you to the correct complaint form. The form can be accessed in a language other than English from the drop down menu on the top. It seems like it's going very fast.
Yeah. I can't control that. Sorry.
Okay.
Sorry.
All right. That's okay.
But you'll see there's
So
different screens that you'll have to fill out with basic information.
yes, there's there's a complaint bureau. You would select the office closest to the manufactured home park. And then you ask you if you will provide your contact information before you get to the complaint form. Although complaints may be submitted anonymously, our office cannot mediate on behalf of anonymous complaints. So if you are complaining that your landlord did not return your security deposit, for example, we will not be able to engage in mediation with your landlord in an attempt for them to return it. That's just one example. Yes, Yvonne.
Can you just put the link to the complaint form in the chat, please?
Yes.
Sure.
Thank
I'll
you.
do that.
Thanks, Justin. So you can file the complaint for yourself or on behalf of someone else. It'll ask you all of that information. So just some important things that I want to point out with respect to the complaint form. The manufactured home park form itself is not, the prompts aren't specifically geared to manufactured home parks. The questions might not seem like they apply necessarily because they're more geared toward retail or service provider complaints. But you do have text boxes, and in those you can clearly indicate the type of relief you're seeking, and clearly advising us of the relief in addition to the purpose of your complaint helps us to better understand our potential roles and the best next steps in the matter. There's also an option I want to point out where you can indicate whether court action is pending or not. It's important for us to have this information because our office cannot mediate issues that were already or that are currently in court. If you do click yes, another box appears and you can provide additional information there. After that, you'll have an option to upload any relevant documents. If you are submitting, you can upload them or you can mail them to us, but supporting information really is helpful, both in if we commence mediation efforts or if an investigation ends up being open. The more documentation we have, the better. So next steps, please note that we're unable to protect the amount of time that a complete review of any given complaint may require, but we're typically able to move forward and contact the individual submitting the complaint or the person submitting the complaint on behalf of someone else regarding the matter in 2 weeks or less. And we will, as far as next steps, we will either contact you directly if we need to request more information or commence mediation. We might refer your complaint to another agency that might be better equipped at handling the complaint, or we keep it on file for a potential investigation. Sometimes when we receive one complaint, it might be the first complaint that we've received, and then over a number of years, we might receive more of the same. That creates a pattern, which would lead us possibly to the enforcement realm. So mediation is a service that our office can provide to consumers. It is the policy of the Bureau of Consumer Frauds and Protection to intervene in an individual consumer complaint or dispute, if we believe our mediation might help bring about a resolution. Mediation allows us to share your side of the story with the subject of your complaint, ask them for a statement of their position, and go from there. It's a voluntary procedure that promotes communication between the two parties and ensures that both sides have a voice in the resolution of a consumer complaint. The subject of a complaint, whether it be a business or a landlord, will often agree to provide partial or full relief, monetary or otherwise, in order to resolve the complaint. But again, it's voluntary, so we cannot force either party to participate and we cannot force a settlement. We are also unable to act as a private attorney for individuals, which means that we cannot provide legal advice or representation. And the attorneys who presented before me today are the individuals who would be providing direct legal advice or representation with respect to the issues that you're facing. So regardless of whether mediation of your complaint against a manufactured home park or other entity is successful, our office may take further action as necessary and appropriate. The OAG has broad statutory authority with respect to affirmative litigation, which is the initiation of legal proceedings in court. Executive Law 6312 is the OAG's main tool when it comes to combating persistent violations of New York state law, including violations of the real property law and manufactured home park tenants' rights under real property law. In addition to or in place of mediation, our office may commence an investigation into a manufactured home park as a result of information received through the consumer complaint process. Our investigation may be resolved relatively quickly through issuance of a cease and desist letter, which, for instance, may require a park to immediately cease a particular business practice, or it might involve issuing a subpoena to the park for documentation or testimony, and ultimately filing a lawsuit or entering a settlement agreement with the park. Just because I saw the one about how many complaints, this is something that's come up quite a bit in practice. There's no particular number of complaints that would lead to an investigation. not specific to manufactured home parks, but landlord tenant issues are, we've commenced an investigation based on two and other evidence. So say a lease that clearly is non-compliant with the law in many respects. So it really does depend on the circumstances. There's no magic number when it comes to complaints and investigations. On the contrary, on the other hand, we might have 10 complaints, but they might not be appropriate for an investigation or enforcement by our office. So it really is, it's case dependent.
I'd say like important thing for people to know too is that sometimes our investigations are confidential, and so you might be asked to provide us information, but we can't always share information back about what we're doing about it. If we do send a cease and desist letter and it's, as a result of your complaint, oftentimes you'll get a copy of what we've written to the landlord, and so you'll be aware of what we've said we think is illegal and what business practices we think should stop. But just understand that our investigations oftentimes take up to 2 years to complete, where the parts of our regional offices, the affirmative attorneys within our regional offices, are a very limited resource, and that's why we have to make sometimes hard decisions. But I will say that manufactured home parks have been a priority for the regional offices in the last couple of years, and increasingly we've brought more and more actions. And for example, there's a park in Sullivan County that we've had to sue twice, called River Valley Estates, and our litigation continues to be pending. However, we brought the lawsuit for violations of New York State law as it relates to persistent problems with the water system, not having clean water. Sometimes there's no water. Sometimes people were under a boil water order for over a year. They also, we believe, have illegally raised rent for some people above 6%. We think that there have been some illegal fees. And so everything's sitting before a judge. We're waiting for a decision on that. But I just wanted to let people know that sometimes these complaints do manifest into lawsuits against manufactured park owners. And we're hoping to, but even in those situations that we're representing the state, and what we're upset about is the fact that our laws have been broken. We are not actually the attorneys for the residents of the park, even though our interests are very much aligned. Obviously, if we get people compensated for having to put up with these water and septic problems, that will benefit the residents, but we don't represent the residents. We represent the whole state and the fact that our state laws are being broken. Just want to make that really clear. And that's the end of the formal presentation. Yvonne, you have your hand raised.
Yeah, one of the residents kept getting kicked out, and he said, "Can you go back and talk a little bit? I keep getting kicked off. What was the attorney answer to the taxes, if you don't mind repeating that?"
So the answer is that with a bit of legal research, we found that there is a case that of a number of residents sued their park owner, and the appellate court held that you can't be charged separately for your taxes, that it has to be included in the lot rent. Like Sam had said earlier, there's not a lot of case law and manufactured home law to interpret these, but it was it being an appellate decision, it holds a lot of weight throughout the entire state. So unlike some of the things that we've been talking about, which are clearly specifically addressed in a statute, this is another body of law that comes out of when cases are heard, and the power of an appellate court to make a decision, and it affecting the whole state.
Okay. Thank you. Thank you, everybody. And thanks everybody for hanging out. We're going to take a few minutes and take a few questions. Tara, I know you were helping me take down questions, but before we continue, when you were just reviewing about investigations, and you can, really share anything, they're asking, how will tenants know if an ongoing investigation has been closed if it does not go to court, but nothing has happened for an extended time? How would people know if the Attorney General's office has an investigation going on? We know, we understand it takes a long time and it takes time, but how would we know if it's been closed or not been closed? Or is it no answer is a good answer then?
Well,
Per se?
you might not know that there's an investigation at all.
Over.
Am I
Got it.
correct in saying that, Justin?
Yeah.
We don't inform when we, and I think Justin touched upon this, but we don't, if we receive a complaint, and say it's not appropriate for mediation, or we attempt mediation and it doesn't work, and we keep that complaint on file for a potential investigation, or we commence and we actually do commence an investigation, we don't notify. Typically, our investigations are confidential. We might need to contact a tenant for a deposition or for more information, but we would not be informing tenants
Great.
that we have an
The-
investigation going.
You'll definitely know if an investigation's over if you see a press release announcing that we achieved some level of relief. Sometimes that relief is the result of a negotiated settlement, which we call an assurance of discontinuance. That is a fancy way of just saying there's an agreement between the Attorney General's office and the target of the investigation that is going to result in some kind of either programmatic changes, or they're going to stop doing something, or they may even have to pay money in the form of either restitution or civil penalties. And then you will know if we filed a case, because there will be a press release when we file the case, and there will be most cases now are filed online, and you will be able to, as a person of the public, be able to look up what's happening in those cases. But to the extent that if you're aware of an investigation and you have not heard anything, it's more than likely still ongoing.
Mm. Okay.
Sorry.
Okie doke. So Tara, you got some questions. We wanna open the floor for a few minutes for Q&A.
Yeah, if I may. So I've literally copied over the whole chat, and I've been keeping track of questions, what's been answered and what hasn't. If I may, to give a brief overview though, no one on this call is going to be able to answer specific questions to your specific park or anything you're specifically going through. And speaking at least on behalf of myself and at LASNY, I cannot specifically advocate that you organize yourselves, merely that you have the right to organize yourself. But a common theme through the questions is, and please, people, correct me if I'm summarizing this incorrectly, but is a sense of kind of fear and desperation that there's no one out here to help you, or that certain residents, especially when they're trying to get an attorney, that they can't find one, or they don't feel they qualify, or things like that. And I do want to highlight that can be something that HOA formation can help with. Again, I've formed multiple HOAs, and I have residents in my parks that individually don't qualify for services, but because they're now a group, the group qualifies for services, and then I can do things on behalf of that group that individual may not have otherwise qualified for. So it can be further ways to get collective relief in your park to continue to work together. There's also that the law only can do so much. Another benefit potentially to organizing is different organizations can work together, not only with the assistance of groups, outside groups like MH Action, and I'm sure there's other housing advocates, not only throughout New York State, but throughout the country that you could connect with. But HOAs can also connect with each other, particularly if you have multiple HOAs who all have the same owner. You can also engage in just non-legal avenue practices, such as you could advocate as residents of New York State to your legislature and to your elected officials. Those are things that lawyers cannot necessarily, especially now legal service lawyers, can help you do. You could go to the press, you could do things like that, that's out of our wheelhouse of things we can do. So I just kind of want to give that brief disclosure, because I think those address a lot of kind of the questions that I was seeing. Go ahead, Yvonne.
And I will say that yes, the presenters on this call cannot like coach you or tell you to organize and stuff, but me being a part of MH Action, being the New York community organizer, I can say to you, let's organize, let's fight, let's stand up for our rights, because we do have rights. Again, reach out to me. I can connect you to other great leaders that are fighting within their communities. We do connections among resident to resident. There is people on this call that are from my sister park, and I will guide them. I will coach them. I will help them. They just formed a tenants association just recently. Is it easy to do? No. But is it impossible? No. So reach out. Let's organize. Let's have leadership meetings where you all can talk with each other. We all can brainstorm, and let's organize and stand up for our rights against these park owners, because it's the only way to do it.
And Yvonne, one of the things that MH Action does is take, the collective experience of different residents of different parks and then speak to legislators about some of the
Yes.
problems that are happening in their parks so that the legislature can change those laws if necessary.
Absolutely. So here's a goal that I'm thinking of, and I'll share it on this call since Justin just mentioned that. We want to get ready for legislation in 2026. We still have a legislation that we've been fighting since 2020 for the loophole fixes in the rent justification. And it has been stalled. It has not passed. And we go to Albany every year and talk personally with legislators. But now is the time in the summer, now before they get into legislation, to start doing Zoom calls with them and pressuring them on what the issues are and what we want them to stand with us, to protect us. Manufactured homes were our so-called the last affordable resource of housing. That is not becoming true anymore. Is becoming unaffordable for many, many families across New York State and all over the country. It is disappearing, and it's up to us, the residents, the homeowners, the leaders on ground, to put pressure on our legislators and meet with them and tell them, share with them our experiences, and ask them to stand with us and to sponsor these co-sponsor these bills and to get them over the finish line.
Yeah, just to be really clear, the Attorney General can only enforce the existing laws. We can't change the laws. And so that's a whole separate part of we're part of the executive branch of government where we enforce laws, but the legislative branch is about changing and making laws.
Okay.
So I do want to respect that we're already 30 minutes past it. So I don't know if we want to get into any of the questions. A lot of the remaining questions are more, even if they're broad, they're kind of more specific. Things like, did the landlord need to hire a process server or things like that? I don't know if the panel wants to go over those, or we could disseminate the answer to these questions with the slides.
I want to suggest something since we're over time also, and I know a lot of people, quite a bit of people has fallen off. We could always, you got a copy of the questions, Tara? We can always review them on a separate call or over email, because we do want to see if we could send a survey so that we could continue planning to do various calls for residents that live in manufactured homes.
Okay, that makes sense.
Is everybody on the call okay with that? Participants, are you all okay with that?
Yes.
Yes.
Okay, so I'm gonna say thank you so much. Can you stop sharing so we could bring everybody back up on the screen?
Oh yeah, sorry. Oh. There we go.
Hey, everybody. So I want to thank everybody for being on this call. Really, really, truly appreciate it. Thank you so much. We will be in contact. I will do an email and thank all of yous and really put the material in a PDF and share it out to all of yous, give you whatever answers to the questions we didn't get to. So really appreciate all of yous. Again, I'm going to specify, I'm going to really push it into you. I will be planning a national New York call for us. And I want all of you to be there so that we can talk about how we're going to reach out to our legislators. What are the stories we're going to share? What is the ask we're going to give them? Because we all need to be together and organized. So once again, I want to thank you all for joining tonight. To our presenters, thank you so much for the partnership. I appreciate you all. A lot of hugs, a lot of love, a lot of peace, and let's continue the fight. Good night, everybody.
Good night, everyone.
Bye.
Thank you, everyone.